A very warm good evening to one and all. First of all, I take this opportunity to welcome each and every viewer who has joined us on this platform on Lex Erudites. On behalf of the team of the Lex Erudites, I welcome each and every viewer today who has taken this effort to join this webinar. Now, first of all, to the new viewers who are not aware as to what Lex Erudites is and what this initiative is, for those viewers, I would like to explain that Lex Erudites is an exceptional initiative, and it is a brainchild of some exceptional, foresighted, visionary law students who are undergraduate law students. And Lex Erudites is actually an e-journal which intends to publish and provide an opportunity and platform for the students and lawyers and many more who wishes to publish their articles on legal topics as well as international and national topics which relate to law as well as society. So anyone who wishes to publish articles, feel free to contact the team team of Lex Erudites. We'll be happy to publish your articles, and this will be a great opportunity for you as well. Now, Lex Erudites is an initiative which was started in July 2020 during the pandemic, and we're all benefiting from this platform, the era of webinars which have started during this period. And we have also got this opportunity to bring in very exceptional personalities from international arenas as well. So we have got a very good participation for Lex Erudites. We have got international viewers from different universities, law students, lawyers practicing in different countries. They've all joined together, and let's make this initiative a great platform. Today, it gives me an immense pleasure to introduce the speaker of the day. But before that, Lex Erudites today has come up with a very interesting webinar and a new area which is developing every day, that is resurrection of mediation in the contemporary civil justice system. Now, today, it gives me an immense pleasure to welcome the speaker of the day. While the flyers were circulating on social medias, everyone were eager and everyone was waiting for this day to hear the speaker of the day, Professor Bryan Clark. Professor Bryan Clark is a professor of law and civil justice at Newcastle School of Law. And he has 16 years of teaching experiences, and he has taught in various universities like the Strathclyde in Glasgow and the University of Heriot-Watt University. And he was also the head of the law school there. Professor Bryan Clark is a socio-legal scholar with interest in mediation and alternative dispute resolution and how these processes interact with the civil justice system. So today we are all waiting and eager to hear the speaker of the day. Without wasting much of our time, I would like to make this floor open for Bryan Clark, sir, to start the discussion. I welcome you, sir. The floor is open to you.
Thank you very much. Can I just begin by saying thank you so much for hosting me today. I'm absolutely delighted to be here. It's great to know that so many people have logged in from different parts of the world and giving up a Saturday, no less. So thank you very much for that. And I'm just delighted to get the chance to participate in this seminar. And I think one of the very small benefits of these really difficult COVID-19 times has been the expansion of online and virtual seminars, conferences, and webinars and student mediation competitions as well. I've been involved in those recently. So this use of technology to reach across borders has been fantastic, and I hope this continues once the pandemic is over. But I really want to applaud the Lex Erudite founders for this initiative. It's fantastic to see a group of young scholars seeking to advance knowledge across borders in legal areas through these series of seminars. They're setting up a journal and using a blog. So that's all absolutely, I think, fantastic. And I'm just glad to be part of this journey and in a small way to help them on that road and help them fulfill their ambitions. So I'm delighted to get the chance to share my thoughts and give you some of my views on mediation and civil justice, and hopefully spark some conversation and debate. I'll try to keep it quite light and conversational. I'll speak for about 45 minutes, and I'd be delighted to answer any questions that you have at the end. I've already spoken to the organising committee a few days ago, And we had some really interesting conversations, and that really helped me to shape the content of today's talk. So, as the title suggests, this re-emergence of mediation in the contemporary civil justice system. So what I'm talking about today is really two things. So mediation on the one hand, and the civil justice system on the other. And the discussion is really centered on bringing these two things together. And it's that embedding of mediation within the formal civil justice system in lots of different ways that has allowed mediation to emerge as a dispute resolution process. So I want to say a bit about, well, how that's happened and also why it's happened in different jurisdictions. I'll talk about the benefits of embedding mediation within the wider court system. And this, I mean, benefits for the increased use of mediation, but also wider benefits for the court system. And wider than that, benefits arising from this for society in general. And there are lots of different choices about how you embed mediation and link it to the formal civil justice system. And there are different examples in different jurisdictions. And I also want to use today to highlight for you some of the opportunities that this presents for lawyers, young and old, and some of the challenges which lie here, including the range of barriers that will need to be overcome if mediation is going to develop as it could, seeing its potential reached to the maximum. Now, I know that India currently is making strides currently in mediation with lots of recent developments and initiatives. I heard, for example, recently that the Bar Council of India now requires law students to study mediation and conciliation. And I'll talk a bit about that later. I think that's very important. And also that the Supreme Court recently asked that a Mediation Act be published or be enacted. And again, I'll talk more about that when I look at regulation a bit later on. But one particular thing that's important here to note is that, in these COVID-19 times, many civil justice systems across the globe, and certainly it's the case in my home jurisdictions in the UK, are suffering backlogs in courts. They're suffering the pressure of the cessation of court business or the limiting of court business, and huge backlogs that need to be dealt with. And mediation may certainly be one of those ways in which we can address some of those concerns. So to begin with some of the basics here, I'm sure you'll all know this, and I just want to cover it quite quickly. But in terms of mediation itself, there are various different definitions of mediation. But just to keep it simple, as you'll know, it's essentially a form of negotiation. But it's a set-piece negotiation, an event, or a series of events, with the added feature of a third-party neutral or mediator, or sometimes mediators, whose role it is to assist the parties to reach an agreement to their problem. And unlike the case with litigation and arbitration, the mediator is not a decision maker. He or she doesn't impose that outcome on the parties, but rather it's for the parties, with the help of the mediator, to resolve it themselves. And mediation is said to have certain intrinsic benefits. And I think it's fair to say that evidence, so research evidence, bears this out. So things like savings in costs and time for parties, the confidential nature of mediation that might be important for parties in disputes, its flexibility, the fact that at its heart, it allows parties to take their own decisions, to agree how to resolve their dispute in the way that suits them best. It leads to creativity in settlement outcomes, way beyond the gift of a court order, for example. And equally, because it's a less adversarial process than arbitration or litigation, it has the potential to preserve and actually enhance the parties' relationship. So we're talking about the new breakthrough of mediation, but of course, in historical terms, mediation is nothing new. It's an ancient process deployed in societies across the globe historically, and you'll find forms of mediation practiced in pre-capitalist tribal societies, in ancient Greek cultures, as well as medieval England. And I know also that it's been present in India for centuries. I was listening to a webinar recently, a fantastic webinar that was put on, that had Sandhana Ramachandran in it, that very well-known Indian mediator that I'm sure many of you know. And she said that over 2,500 years ago, India gave mediation to the world when the Buddha chose mediation as the wise choice. So you'll find examples of that in many jurisdictions historically. So although we talk about mediation as this new alternative way of resolving disputes, it really is the traditional way of doing it. It's the courts and formal civil justice. In relative terms, they're the modern approaches. But, of course, nonetheless, when we're talking now about the resurgence of mediation, we mean as part of this modern alternative dispute resolution, or ADR movement, which was born in 1976, this famous conference, the Pound Conference in Minnesota, USA. And this was a conference set up by lawyers and eminent legal jurists and judges to discuss the problems with civil justice, which were present in the United States at that time. It was where Professor Frank Sander, first coined that term, alternative dispute resolution. It's where we first began discussing the idea of a multi-door courthouse. So this is a court in which parties just don't simply seek to resolve their dispute by legal judgment, but there may be different doors in the courthouse leading to arbitration, mediation, or litigation, or other options. And obviously one of the key options that sprung from the Pound Conference was the possibility of mediation. So diverting cases which otherwise would go to the civil courts to mediation. And this led to the development of court-sponsored mediation throughout much of the USA. And that model has spread to many jurisdictions across the world, including India, including the UK, New Zealand, Australia, continental Europe, many, many jurisdictions. But it's worth, I think, remembering a bit about why the Pound Conference came about. As the situation in the States at that time, there was a crisis in the civil justice system. The courts were creaking at the seams. They were overburdened, subject to huge delays. There had been what was called a litigation explosion at that time, that there were too many cases being brought. Lawyers were promoting litigation for causes that were not actually worthy. And we needed to save the courts in some way, preserve them for the most important cases, and sift out all the others. And to one extent or another, those problems are apparent in other jurisdictions today. Now, Chief Justice Warren Burger, who was very prominent in the Pound Conference at that time, he was very blunt in his assessment of US society at that point. He said it was dominated by the law and lawyers. He said, we're on our way to a society overrun by hordes of lawyers, hungry as locusts. Apologies to any lawyers in the room, but very much an interesting point put forward there. There was too much law, too much litigation. Mediation was seen as some kind of salvation for that. Now, it's fair to say that at that time, there were other groups operating in the United States who'd set up grassroots community mediation programs. And they were true believers in mediation, who saw the process as a true alternative. They believed that it was a fundamentally better way to resolve disputes than by going to court with all the acrimony and win-lose approach that's taken there. And a lot of those programs had nothing to do with the courts whatsoever. But the truth is, and I think it's in some ways an inconvenient truth, but it's true nonetheless, that a lot of those programs really suffered and they struggled to take hold. And mediation only began to really develop significantly when those schemes began to be linked to the court system. And we've seen that pattern repeated in many different jurisdictions across the globe. So it's a bit ironic, I suppose, that mediation, which, in some ways represents a turning away from the law, a turning away from lawyers and courts, it only really develops in a broad sense when it becomes somehow linked to the formal civil justice system. So I think it's important to reflect on why this might be the case. Why do voluntary mediation initiatives that sit outside the legal system often struggle to do well? And I've thought a lot about this question over the years, and I think despite the fact that mediation seems like a very common sense way of resolving matters, and it does have a good track record, if you look at the research, the evaluation in different jurisdictions and contexts, evidence suggests that parties often settle cases in mediation. They often report saving time and money. They were satisfied often with the process, with the outcome, the way the mediator behaved. They would, and sometimes they do, mediate again. But despite that, we know that getting parties who are in the middle of an actual dispute to mediate is just not that easy, especially if they have not been involved in the process before. And so you might stop somebody in the street and explain to them what mediation was about and talk about the benefits. And you would ask them, do you think that's a good idea? And of course, they might say, yeah, that is a good idea. And if I had a dispute, I might well mediate to resolve it. But it's quite different when you're dealing with people in the midst of an actual dispute. And to think about why that's the case, I want you all to reflect yourself on how you feel when you're in dispute with someone. And it doesn't have to be a legal dispute, a serious dispute, but when you've fallen out or have a difference with somebody, matters may become acrimonious. The parties become quite polarized. Each one wants to win. They want to enlist champions to fight their cause. They want their day in court where the judge says, you are right, they are wrong. You want to see your opponent on their knees getting what they deserve, hopefully in public. And mediation, with its promise of compromise and talking to the other side amicably, bringing in a mediator who will be neutral between you, it doesn't sit easily with this. And it's quite a hard sell. I do remember reflecting on this quite a bit myself. A number of years ago, I sold my house. My family sold the house. And we found a buyer, and they were going to move in 3 months' time. And at that point, transfer the funds over and move in the house. In the meantime, we found another house and arranged to move in on the same day and complete the contract, on the same day. The day before the buyer of my house was going to move in, they contacted us to say that they couldn't actually find the money because they hadn't sold their own house. And we only found out the day before. So it ended up that we had two houses for a long period of time, paying two mortgages, very, very difficult and stressful circumstances. But eventually, a few months later, the buyer did sell their house, get the money, and they moved in. And I thought, thank goodness for that. Everything's sorted. But a couple of weeks later, in fact, we received a lawyer's letter from the buyer of our house with a list of a huge number of snags, things they were unhappy with the house, that the heating wasn't hot enough, the water pressure wasn't good enough, there was some staining on the walls, there was some problem with some electric switches, as if we'd sold them a brand new house, and this was the list of snags. And they were seeking quite a lot of compensation. And I remember being so unbelievably angry immediately and consulting my lawyer and saying, this is ridiculous. We've been so kind to them. How dare they do this? And it escalated for some time with lawyers, letters going back and forth. And I thought about it then, if mediation had been suggested, and I know how good mediation can be and the track record of it, I would have been very, very reluctant to do it because I wanted to win. I was sure I was right, and I felt offended by their complaint. And anyway, the case did ultimately disappear. I think they didn't really have much of a legal case, but it did get me to think, well, how do people in the middle of a dispute think about mediation? The other factor is lawyers. And lawyers advising clients in many areas of dispute, of course, they may too resist mediation. Now, they might be over-optimistic in their assessment of a client's case. They may see no need to compromise because they're going to win. And after all, they want to please their clients by saying, yes, of course I can represent you. Of course I can present a good case. Now, lawyers and others, all of us, when we're in dispute with someone else, we can suffer from what's called confirmation bias. And this means that we see what we want to see. We scan for evidence to support our cause. So it might be precedents in case law, for example, or facts that we can bring to bear to support our case. But we ignore other evidence which isn't so convenient for our case. We quietly ignore it, perhaps without knowing that. And certainly there's some evidence that lawyers may be over-optimistic in advising clients on their case. But equally, lawyers, who act as gatekeepers to a great extent to mediation, they may be simply ignorant about mediation's value. They may lack confidence in the mediators, and they may also find that it doesn't fit well culturally with their normal way of working and handling client disputes in a legal practice, which is negotiating on behalf of a client, running the case for some time, and at quite a late stage often, at least that's the English experience, at a late stage, settling the case. And mediation represents a challenge to that. Lawyers also like to be in control in mediation, there's an element of ceding control to the client that may be uncomfortable for lawyers. There's an element of the unknown about mediation. They're not sure of their place within it. They don't perhaps want to look foolish in front of their clients. And also, of course, there is this concern that mediation growth will serve to sideline lawyers and negatively affect their revenue streams. And I suppose on this last point, it's quite ironic that, in fact, the opposite has occurred in many circumstances. So in the US, for example, where in commercial matters, mediation is big business for law firms and a very lucrative endeavor. So because of this reality, this difficulty getting people to mediate, mediation providers, as well as governments and courts, have had to put their heads together to develop carrots and sticks to persuade and pressure parties into mediation use. So normally there might be some kind of intervention where those seeking to access courts or tribunal are either given the opportunity to sample mediation's wares, or they are steered with varying degrees of pressure towards participation in mediation. So let's talk about some of those different ways next. I think, at the most extreme end is mandatory mediation, where parties seeking recourse to a court or a tribunal are compelled to attempt mediation first. Now, this is commonplace in many jurisdictions, so parts of the USA, Canada, Italy, for example. It's not currently found in England, at least in a formal sense. Now, I'll talk a bit about that a little later on. I do understand that the court in India may under Section 89 of the Code of Civil Procedure to mediation. And equally in commercial matters, in the Commercial Courts Act, there have been recent amendments which say that it's mandatory for parties to exhaust the remedy of mediation prior to bringing a suit. And as I've said, mandatory mediation, is found in many jurisdictions in different forms. But I do think it's highly controversial as a practice. And by all means, it's certainly not something promoted by everyone in the mediation community, even though it might give them more work, because they believe in the fundamental virtue of mediation, the parties' voluntary participation. And I think also it doesn't sit easily, at least, with the notion of the ability to enforce rights in a democratic society. We are given rights under the law that we can enforce against others. And if there are some barriers in the way to that, then the rights become less meaningful. That's the idea. So there's a constitutional rights angle here, or a human rights angle to this. There has been a great deal of discussion about this in England, certainly. There's a famous case that some of you will know called Halsey, that determined that mandatory mediation would be contrary to Article 6 of the European Convention on Human Rights, this right to a fair trial. And that view, although it may be a view that was expressed in obiter terms, which technically means it's not necessarily binding, it has in fact been, very, very influential over the years. It's coming under some attack now, but that still seems to be the prevalent view in England, although for how much longer, I'm not sure. But on the other hand, so arguments, if you like, in favor of mandatory mediation, certainly compelling somebody to mediate doesn't necessarily compel them to settle in mediation. We're not saying you have to settle, you cannot access the ability to enforce your rights. You're just saying to them, you've got to attempt to resolve it first. And another defense, I think, to compulsory mediation is the fact that in many areas of legal practice and litigation, it's clear that the vast majority of cases will settle anyway. So looking at civil litigation in England or Scotland for that matter, there's lots of evidence suggesting that upwards of 95% of cases filed in the civil courts where parties are seeking a judgment, they settle in any case. So if you were to compel parties to mediate at an earlier stage, all that you're doing is replacing one form of settlement with another. And the state has a vested interest in getting parties to settle more quickly. It will save time and money for the state, free up court resources for cases that need to go to trial. Of course, the other practical argument is that it just doesn't work. You can take a horse to water, but you can't make it drink. And if you drag people kicking and screaming to mediation who don't want to be there, they'll simply waste their time. It will be a waste of resource for everyone involved. I think certainly there's a legitimate argument that if mediation is deployed too early, then parties may not be ready to settle. They've not had enough of the pain yet of being involved in litigation to know that they really need to settle. I mean, that's what happens normally in a late settlement. But early on, they're not ready to hear that. And equally, lawyers might say, well, if it's too early, parties cannot make informed settlements. That's why we like to settle late. We need to bottom out the case. And I've got only limited sympathy for that argument, to be honest. But I think what we do know is that even the most difficult cases, where parties genuinely don't want to be there, and they're only in the room because they have to be, we know that even in those cases, mediation can work. There is a magic about mediation which can occur in the room, where cases that looked absolutely hopeless, where lawyers and parties have failed to agree, are in completely polarized positions, nonetheless, they're able to get a solution. And it's about the ability of mediation to break down the barriers between the parties, to get them speaking to each other honestly and openly for the first time in months, if not years, to find what the parties' underlying interests are, to look for shared interests. So in my view, and there's evidence to back this up too, and certainly mandatory mediation can work in terms of resolving cases. As a final point here about mandatory mediation and any case where mediation is significantly linked to the court system in some way, that does inevitably place the mediation process under further scrutiny and emphasizes the need for greater standards in training, regulation, accountability, and also puts certain aspects of the process under scrutiny, such as confidentiality, and when confidentiality in mediation might be waived. We can perhaps talk about that a bit later. And you also have to be sure that you invest in the facilities so that if parties are referred to mediation, then a good level of process is available for them. So if we're talking about low-level disputes with parties in small claims for low values of money, perhaps about lawyers, if we're saying to them, you must attempt mediation first, the mediation service must be properly funded and run with good facilities so that those parties are not shortchanged in a shoddy process that doesn't protect their interests. So aside from mandatory mediation, I want to just quickly review the other ways in which, or some other ways in which, mediation can be promoted by the justice system. So it's possible to have a system whereby parties are compelled to obtain information about mediation from a mediation provider. And that is compulsory, but it's not compulsory to actually mediate. That may be more palatable to mediation critics and even those in the mediation community who are unhappy or uncomfortable with mandatory mediation. This is something in the UK we've had in our employment tribunals for many years. It's a process called early conciliation. And it's essentially parties, before they bring an action, they must find out about the possibility of a conciliator helping resolve their dispute. It's also an approach found in respect of family cases arising from separation and divorce over custody and access to children, for example. And it's quite a common way of proceeding. And equally, again, rather than mandatory mediation, another subtly different approach is to have mediation as a default process. So it's not compulsory, but it will apply unless the parties specifically opt out. They don't have to make the effort to opt in, which can be difficult, but rather they will opt out if they want to, but otherwise automatically they refer to mediation. And this is currently being used in a pilot court scheme in England, the Manchester County Court scheme. The final way I want to talk about the ways in which mediation can be promoted through the court system is what we have in England currently, which is this idea of cost penalties for unreasonable refusals to mediate. Now, obviously, in many civil cases, the costs that the parties run up can be highly significant, and much of the time, more than the actual amount in dispute. So the allocation of costs, so which party might receive some of their costs from the other side, may be absolutely paramount. Now, we do have this general loser pays principle, which means that generally speaking, if you lose the case, you'll pay a proportion of the costs of the other side and also meet your own costs. But in this unreasonable refusal to mediate regime, if at some point in the court process, the other side suggests to you that you should mediate, or the court makes that recommendation, then even if you win and the court viewed that your refusal was not reasonable, you could be penalized heavily in respect of costs. And the difficulty with this regime is that it's very difficult, I think, for lawyers to be confident in advance as to whether or not they can refuse to mediate if the other side makes an offer. There have been cases which set down guidelines, but the law is not consistent, it's changing. So it's not an approach that I actually like that much, but it's the dominant approach that we do have here in England at the moment. The final thing to say about, in terms of court-based mediation is, well, who provides the mediation? Now, of course, it may be external mediators, some who operate privately or who are on court rosters. Many may be lawyers, of course, and of course, sometimes they're judges. And I just want to say a little bit about judicial mediation very quickly here. And judicial mediation, where a judge mediates the case, has become common in lots of different jurisdictions. So in the UK, in our employment tribunal system, we have judges, employment judges, who offer mediation in respect of employment disputes, such as unfair dismissal. And I think that judicial mediation is often seen as quite attractive for parties in dispute because, of course, the judge is someone with real authority. You know, this is a person who is important enough to hear my dispute, someone of very high level and gravitas. This is what I want to hear. And equally, a number of retired judges, particularly in the US actually, will mediate in lots of high level commercial cases. So there's a body called JAMS, involving many retired judges. You may have heard of JAMS. And they're highly in demand from parties in high-level commercial disputes. And I'm sure that many of them are extremely good, of course. But I think one of the problems with having a judge, I think particularly a sitting judge, so not a retired judge, but a sitting judge, is that even if that judge is trained very well in the ways of mediation and knows that it's not his or her role to express opinions or tell parties what to do or evaluate the case in any way, nonetheless, the parties still know that they're a judge and they may treat them accordingly as a judge. And I think that may make facilitative mediation, classic mediation, helping parties explore their own interests, it might make that quite difficult. And I mean, equally, I'm sure there are some judge mediators who would find it quite hard to cast off their judicial robes and may continue to act in a judge-like fashion in a mediation. This reminds me of a story that one of my colleagues and good friends told me. In his time shadowing a judge mediator in the United States, he was a JAMS scholar and was given a great opportunity to go to the States and see these high-profile mediators in action. And the judge mediator in the introductions asked the parties if it was okay to use their first names to address them by, as is commonly the case in mediation. And of course, the parties agreed. And then one of them said, what shall we call you? And quick as a whip, the judge remarked, you can call me judge. I want to just quickly talk about developments outside of the courtroom or other ways in which mediation begins to become normalized, if you like, or institutionalized. And mediation, of course, may take place on a voluntary basis outside of the court or tribunal process. And certainly some family cases in Scotland and England, employment cases, community and neighbourhood mediation takes place this way. What you often find is that once the court starts to promote in different ways the use of mediation, and its use becomes more widespread, that can lead parties to start to use it on a voluntary basis. Lawyers become used to the process. They have good experiences. They return to it. Another important way that you can help embed mediation, particularly in commercial matters, is through this growing trend of embedding mediation within terms in contracts. And what I mean by that is where there's a clause in a contract which governs the contractual relationship between the commercial parties. And the clause will stipulate that if a dispute arises in respect of this contract, then the parties will first seek to resolve it by mediation. And only if that fails, may they then have recourse to arbitration or litigation. And my own view is that this is potentially a very, very useful way to spread the word about mediation and normalize its practice in commercial matters. Now, in England, certainly, it was initially felt, going back maybe 30 years, let's say, that such clauses lacked any legal enforceability because they were mere agreements to agree. And an agreement to negotiate, an agreement to agree is not historically binding under English common law. But nonetheless, there was a famous case called Cable and Wireless, which affirmed that such clauses could be legally enforceable if the clause mapped out in precise and specific terms clearly what the parties' obligations would be in respect of the mediation. So setting out the form of mediation, perhaps, how the mediator is appointed, which body will oversee it. And I think that's been very important, and that's a well-established principle in case law now. Right, I want to move on a little bit now and talk about lawyers and mediation. I have already talked about lawyers being resistant to mediation, But equally, there's no doubt that many lawyers have become drivers of mediation. They've become enthusiasts, champions for its cause. They've sought to promote it to their clients and their fellow lawyers. And of course, one issue that is key here is mediation education for lawyers and law students. As I said at the beginning, I heard that recently the Council of India, the Bar Council of India, mandated that mediation with conciliation shall be a compulsory subject taught on the LLB course. Now, I think that's an absolutely fantastic step, and I want to say a bit more about this now. Obviously, there is a career angle for new lawyers. Mediation is a growing field in many jurisdictions, and mediation education and experience is being sought out more and more, I think, by employers. Now, it is very hard in my experience for young lawyers and other professionals as new mediators to break into the mediation market, especially at the higher end, the commercial end, because mediators at that level, they're often appointed not simply because they are trained as mediators, but rather because they are experienced professionals with significant reputations in other fields, and quite commonly the legal field. But certainly new lawyers and law students will soon find themselves potentially representing their clients in mediation as party advocates. That's the way that most new lawyers will first encounter mediation, or at least they will be in a position of advising clients as to whether or not mediation might be a viable option. So I think that mediation education is essential. But I think it's essential for law students, whether they go into mediation or ever encounter it again or not. Now, the traditional law school focus in the UK, as well as the US, and I'm sure in many other jurisdictions, has been to teach students in a very narrow way about the law, how to analyse cases, to interpret statutes, to provide legal advice to clients, to present a winning case. It all happens in a vacuum. You don't think about anything else apart from the law. Mooting and advocacy activities are highly prized in law school. So I think against that backdrop, mediation training is not actually that easy for law students. As mediation advocates, they have to think beyond the law. They have to give their client room to speak and set the agenda. They have to try not to seek to narrow the focus to legal argument all the time. They have to balance their adversarial preferences, their need to better their opponent with clever argument. We've all been there as lawyers. They've got to balance that with collaborative moves and see where compromise is essential and think creatively. I think it's even harder for law students and some lawyers to mediate. Against all your instincts, you cannot pass judgment. You're not there to solve the problems. That's a big misconception. You're not there to render advice or tell parties what they should be doing. You're there to ask open questions, to find out what the party really thinks, to ascertain what the important issues are for those parties. You have to express a genuine curiosity to uncover the party's interests from them. A colleague of mine, who's a brilliant trainer and mediator, Charlie Irvin, he said that mediators have to ask what we in Scotland call the daft laddie questions, what may seem like stupid questions, asking what may be obvious things, but don't assume anything. You may make a range of assumptions as a mediator, but they may be wrong. It may not be what the parties believe. And of course, it's said that lawyers normally only ever ask questions when they already know the answers. So this is sometimes, I think, a real challenge. I would also say that mediation training simply makes students better lawyers. It can open up law students' eyes to the vast number of factors which dictate what advice to give a client of which the law, and how strong a case might be, is only one. We learn about clients' interests, their appetite for risk, their need to preserve reputation, their need to preserve a business relationship, the need for confidentiality, their financial pressures, and their need at times to move and resolve matters quickly. And in training students, they also develop negotiation skills. They become better at communicating. They become better at reading others and seeing things from different perspectives. They learn creativity. It makes law students better deal makers as well, not just about resolving disputes, but crafting deals. And I think that fundamentally, students get to know themselves better. And I think for all of us, that's a very important piece of learning in life. So I want to finally move on to the issue of regulation in mediation and say a few things about that here, not too much, before we open it up for questions. I know that there's very or relatively little regulation of mediation activity in India at the moment, but there is this new Mediation Act which has been proposed, which could consolidate some of the existing legislative provisions in the area and also bring about a new regulatory framework for different aspects of mediation practice. In my own jurisdiction, so I was born in Scotland, but I work in England. And although they're both in the UK, they are somewhat confusingly two separate and distinct legal systems. You've probably noticed we also have two separate international football teams, which is a bit of an anomaly. But yeah, we don't want to lose that, absolutely. Probably more need to hold on to that than the separate legal system for those in Scotland. But within the UK, there's very little formal regulation of the mediation role. So anyone can hang a shingle outside their door and advertise their services as mediator. The term mediator has no protection. Now, having said that, there are a range of professional bodies who are prominent in the field, who set standards and accredit those who meet those minimum standards. So you have the Civil Mediation Council in England and Scottish Mediation in Scotland. You also find in certain areas there is much more tightly controlled self-regulation measures, such as family law, where the training, the supervisory requirements are much tougher than in general commercial or civil practice. And I think this approach of primarily being a self-regulation approach is very common typically in common law countries, but they are moving now towards more formal regulation. And we've always found formal regulation more common in civil countries, such as those across continental Europe. So should we have more regulation? Well, I think that new pieces of legislation, and I think almost regardless of their actual content, they always make a splash and they raise the profile. So they would raise the profile of mediation. We've seen this with the recent passing of the Mediation Act in Ireland that really raised the profile of mediation there. And also, of course, in the context of cross-border commercial disputes arising from the Singapore Convention, which has really, no doubt, raised the profile of international commercial mediation quite significantly. And I know that India has signed the convention, but not yet ratified it. Certainly, new regulation can help to lend legitimacy to the process. It can give greater confidence about the quality of mediators to potential users and their lawyers. It can set minimum standards in things such as professionalism, determine ethical rules for practice, set minimum training requirements. It can deal with things like continuous professional development needs, mentoring and supervision requirements. It can establish disciplinary codes for those who act below the standards required, and also put in place consumer complaints mechanisms. And equally, it's not just the mediators who may be regulated, but the mediation process itself and certain aspects of the process itself. So, for example, in areas such as confidentiality. Now, in England, generally speaking, most mediations are not governed by particular rules set up for confidentiality in mediation, but rather by general common law rules, what are called the without prejudice rules, which apply to all pre-trial negotiations. And there's certainly an inherent, I think, uncertainty about the way they apply to mediation, which isn't helpful. And equally, you can legislate about the enforcement of mediated outcomes, make changes to the laws on limitations to allow space for mediation to take place. I also think that regulation can also properly or help to properly professionalize the field. Something lacking, I think, in many jurisdictions, where mediation is not seen as a separate profession, but rather an adjunct to other roles, such as the legal profession. And regulation could certainly, I think, help new mediators get a foothold in the field. But not everyone is in favour of formal regulation. And many mediators would argue that the market will suffice to root out malpractice. Word gets around about who the good and the bad mediators are. We don't need regulation. We don't want it. But of course, one problem with this is that markets rarely work in a perfect way. In commercial mediation, it's quite often the lawyers who, as repeat players, are the buyers of mediation services. And the lawyers may have certain preferences for mediators. Now, it's quite often lawyer mediators. The lawyers may have a preference for evaluative mediation that focuses on the legal issues because it suits them, but it may not necessarily be the best form of mediation for their client. And equally, if you look at other jurisdictions, such as Greece, for example, in that jurisdiction where there has been recent legislation, Greek lawyers have been very clever in being able to, if you like, they've been clever in being able to really influence the policymaking process, allowing their interest to be protected. So in Greece now, where there is this formal regulation, in Greece, if you want to mediate the case, you have to be a Greek lawyer in many circumstances. And if parties want to mediate, they have to bring lawyers with them. So sometimes those powerful groups are able to exert influence on the way that regulation is crafted. And finally here about regulation, it can be difficult. I mean, one of mediation's great strengths is its flexibility, practice models, and importantly, a huge, diverse set of cultural preferences among potential users that applies across jurisdictions, but also within them, and I'm sure that applies to India. And regulation can narrow the definition of mediation. It may prescribe a certain practice model. It may limit those who practice it. It may put barriers in the way of grassroots enthusiasts. It can be expensive to operate and become too rigid. And I suppose my own preference is really for a mixed or a co-regulation approach, with legislation setting out the broad parameters, but the detail devolved to professional bodies active in the field, which keeps it flexible, responsive to parties' needs, and informed by the mediation profession. So I think I probably said enough there. I went on a little bit more than I expected, but thank you very much for listening. If I can just give one final thought, which is that mediation is so much more than a dispute resolution tool. It's a life tool, and I think we can all learn from it in every parts of our lives. So thank you very much.
So we would like to move on to the question and answer session. So I'll begin with the first question. that is mediation culture is an indicator of a progressive society. So is there a need to impart the culture of mediation in the contemporary civil justice system or in the society as such?
Yeah, I mean, I think that's a very good question. I was discussing with colleagues before about the fact that mediation isn't simply a form of dispute resolution. And I think if you're going to grow mediation, it can grow so far through the justice system. But equally, you want to embed mediation and mediatory activities within activity in society at all levels, because mediation can be used not just to resolve disputes, but also to stop them occurring in the first place. It can allow people to engage with each other in a way that prevents disputes arising. One of the great initiatives that we have in Scotland and other parts of the UK is what's called peer mediation within schools. And this is where mediators go into classrooms and they help children, and often for quite young children, resolve their disputes using mediation techniques. And I think that kind of education is absolutely key in making a better, a more harmonious, less adversarial society. So yes, I would agree with that. The other difficulty is if mediation only develops through the formal civil justice system, there is a danger that it becomes overly affected by that system and begins to mirror the formal civil justice system. It becomes more legalistic, it becomes more adversarial, it becomes more evaluative. And there is evidence of that in different legal jurisdictions, and we need to be wary of that as well, I think.
Right, sir. So the next aspect which I would like to touch is that vast majority of lawyers, as you had very rightly pointed out, view mediation with the lens of suspicion. And they are very resistant to the concept of mediation. So when we are talking about imparting the culture of mediation into the society, what would be that piece of advice which you would like to give to the law students who are viewing and to promote that culture of mediation in them so that when they become lawyers, this concept or this suspicion is gone? Yes, sir.
Yeah, I mean, I think it's something that's going to take a long time. There is a suspicion in legal circles regarding mediation. To some extent, that's based on misconceptions about the process. To some extent, that may be about it being a challenge to the cultural norms in the profession, as I said, or a challenge to revenue streams. But I think for law students, I'm saying to them, look, this is happening whether you like it or not. Mediation is developing in different ways. Civil justice systems are adopting and embracing mediation. They're seeing the true value in it. And it would be far better for you to embrace that, to be at the front of that, to be somebody that's what Julie McFarlane, who's one of the law professors in the States, calls a new lawyer, who isn't stuck in the old adversarial ways, but rather knows that their primary duty is to their client, to represent their interests to the best of their abilities. And clients may need mediation in a way that they don't necessarily need litigation. And think about what's of importance for your client. Think about their interests. And it's difficult. So when new lawyers come into legal practice, as many of us will know as a junior lawyer, you've got very little influence. You do as you're told. If you tell the senior partners, well, why are you not mediating more cases? You're going to get shot down. So you need to bide your time, do all that you can, influence as much as you can, build up a mediation practice and seek to influence others. But it does start in law school. And I think law professors, law schools are very much complicit within this. We have peddled the idea of adversarial justice. We have taken client needs out of the equation. We've looked for this focus on legal issues above all else, prize, muting and advocacy. So law schools have to change as well. But I think that's happening. And more of it needs to happen in the future.
So, a continuation of this, that is, while imparting the education of mediation in the law schools, how effective can be mediation clinics to train the law students? So,
yeah, I think this is a very good question as well. When I previously worked at Strathclyde, the colleague of mine, Charlie Irvin, he ran a mediation clinic that was attached to a mediation master's program in law that we ran there and still runs. And so students that came across to undertake that program, once they'd done their basic mediation training in the class, they were given the chance to join the clinic. And effectively, they were paired up with experienced mediators who gave up their time freely, thankfully for us. And the students with the experienced mediators mediated real cases, quite often cases occurring in the local sheriff court, so quite low-level cases in Scotland. And they were exposed to real cases and real clients and real practice. And I think that law clinics in general are incredibly valuable because it's different to tell students about legal practice, about dealing with clients. We can role play, we can do role plays in class scenarios, for example, but there's nothing like for students dealing with real clients. That's quite frightening, actually, real people with real problems and making a difference in the real world. So I think clinics are a fantastic development. I would really encourage, if it's all possible, the establishment of clinics, both mediation clinics and also legal advice clinics in law schools as a great way for students to really put their learning into practice and to start to reflect on what they've learned and think about how they put that into practice and how they can develop further as a reflective learner, as someone gaining experience in mediation. So yes, I would certainly encourage that quite significantly.
Yes, sir. So quite often we have been hearing of agreements where an arbitration clause has been added. So how do you see the possibility of a mediation clause being added instead? And how effective will that while drafting the contracts and agreements?
Yeah, I mean, I think this is something which is becoming more common. I think you're right that historically parties had arbitration clauses, for example, or they said they would resolve the matter in the Commercial Court in London, for example. But we're seeing, I think, more commonly now, multi-tiered dispute resolution clauses, with the first part being that if a disagreement arises, the parties will seek to resolve it by mediation. And I think this is a good way of promoting mediation. In international contracts in particular, we've seen certainly an increase happening in that sphere, and also in national contracts, because it normalizes the process. It becomes part of the traditional way of resolving disputes. So mediation is not an exception. It's something that's accepted as a step. And as I said, although historically, my understanding was in England that such clauses were doubted in terms of how enforceable they were, that is no longer the case. And certainly if a clause is carefully drafted, it's likely to be held to be legally enforceable. So parties would require to mediate before they would be able to invoke arbitration proceedings or go to court, for example. And I think in commercial matters, there's a big role to play for in-house commercial lawyers. So in-house lawyers, general counsel, who may be responsible for drafting these contracts, to ensure that they're able to put these kind of clauses in. And I do think this is a way that we'll see more and more mediation taking place in those areas.
Yes, sir. So when you say that the agreement should be carefully drafted, both with regard to arbitration as well as mediation, so how do you see the possibility of training the lawyers? That is to be required, or we need trained lawyers or who are equipped with sufficient information as to how to draft an agreement without pathological clauses.
Yeah, I mean, I think that again is a good point, because there are obstacles here, and a clause that's poorly drafted isn't going to be enforceable, perhaps, and there's quite a bit of English case law about that. It's about legal education again. Certainly, I've become aware that aside from just mediation training for lawyers and others, there's been a growing interest in mediation advocacy training, which is not just how to represent clients within a mediation, but how to prepare for a mediation, how to decide whether or not mediation is useful. And I think content within that kind of course, looking at specifically how lawyers can ensure that they can embed mediation clauses in contracts, would be very useful. There perhaps is a lack of knowledge about that currently, but certainly that knowledge needs to grow. So it's an issue of education, I'm sure.
Yes, sir. So I would like to go back to the discussions. The point which you had put in, it really fascinated me. That is the concept which you put in, that is the party should be given a liberty to opt out of mediation. So that was a very interesting concept. The point which I would like to add in there is that, sir, there is compulsory mediation or mandatory mediation. If there are compulsory or mandatory mediations, then what are the advantages and disadvantages of this mandatory clause of mediation?
Right. So I suppose so. A couple of things there about the opt-out system. So that's not mandatory mediation. That's saying that mediation will occur as a default unless you opt out. There is this idea that it's easier for parties to opt into something than to opt. The idea is, I'm not explaining this very well, but the idea is that parties are more likely simply to stick with something and not opt out of it than they would be to specifically opt in to mediation. It's a slight difference. This idea of nudging parties, you've maybe heard about the book Nudge, this idea of nudging parties along to a certain pathway. And that's one way of saying that it's not quite mandatory, but you can opt out. And that might be one way of proceeding. The point I think you were making about contracts, if mediation is mandatory through the courts anyway, then why have clauses in contracts which compel the parties to mediate? I suppose it's because in those contracts, and I'm thinking about, let's say, international commercial contracts, that parties are highly unlikely or might be quite unlikely to litigate, at least initially, and they're more likely to be looking to have recourse to arbitration. So they won't come before the courts where the courts would compel them to mediate. They'd be looking to arbitrate. So a clause in the contract saying that's fine, you can arbitrate, but let's mediate the dispute first, I think would be a good step to help promote mediation in these areas.
Very well said, sir. Sir, another thing or another concept which I would like to bring in, I would just give an example of India. That there are many backlog of cases in India as well, whether it be civil or whether it be criminal courts. They're all burdened with n number of case files and backlog of cases. So my concern is whether mediation can be used as a potential tool to reach out and make amicable settlement in less grievous criminal offenses to minimize the backlog of cases. So how can that concept be used?
Yeah, I mean, I think the way that mediation operates in the criminal sphere is slightly different from the civil sphere. So in civil cases, the dispute is reframed essentially as a disagreement between the parties. And mediation doesn't look to find fault necessarily between the parties, albeit that one may apologize to the other in the course of that. But in criminal matters, it's slightly different in the sense that in criminal matters, it does involve an offence that somebody has committed against the state. And some kind of admission or acceptance of responsibility may be required. But I do know that mediation in this context is used. So we have in the UK what are called restorative justice schemes, where parties who've perhaps been accused of a minor criminal offence can avoid formal prosecution by agreeing to make good or make reparations to their victim. And that may entail meeting with the victim and admitting responsibility, apologising, explaining to the victim why they carried out that act, and also perhaps listening to the victim and for the first time perhaps as an offender, understanding and realising the impact that your actions had on the other side. I think criminal justice generally doesn't really promote that kind of thinking. We tend, if we're accused of a crime, we tend to focus on ourselves, how we can avoid punishment or minimise punishment. We can fight our case. We don't think about the impact of our actions on the other side. And there's some evidence that involving accused persons within these mediation schemes can lead to a reduction in reoffending rates in the longer term, as well as being beneficial to the victim. And equally, as you said there in the question, diverting cases away from the courts. You have to be careful because there'll be some that see this as some kind of soft option, that the state is not dealing with offenders appropriately enough and punishing them. But, this is difficult. Reparation and mediation or restorative justice, it's pretty tough for offenders to go through. And it can lead to really, I think, quite meaningful outcomes.
Yes, sir. Yes, sir. I would like to add on another situation. Let's say there is a person who has a grievance. Now, this person has a grievance and he institutes a criminal proceeding or a civil proceeding, whatever the case may be. Now, the object and the purpose which he has inside him is to punish that person or to take out revenge against that person. And his objective is not to settle that matter, but to harass that person. So, in that particular case, how does a mediator tackle those situations and how to overcome that situation, if that is the case?
Yeah, I mean, I think those situations are incredibly difficult. I mean, absolutely. And as I said before, there will be cases where parties really just want to punish the other side because they're so angry and upset. And, there are going to be cases where mediation's not going to be possible at all, and clearly that's the case. But I think it's about, talking those things through with the person who's angry. I think a key thing that mediators can do in those situations to try to diffuse the tension, well, there are a couple of things. One is that to some extent, you've got to allow that person to have their say within reason and vent. That person wants to be listened to. They want somebody to hear and acknowledge the fact that they have a problem, that they feel this way. You're not sympathizing with them, but you're understanding that they do feel this way and you're recognizing that they feel this way. So that's one thing. And I think then you want to try to get the parties to reflect on their own behavior in that if you possibly can. Because we tend to see things through a very biased lens when we're in these situations. We may, of course, be very quick to pounce on what we see as negative behavior from our opponent, but we don't really reflect on our own. And actually, once you tell that story, there may be different ways of viewing that situation. And you also have to talk through the consequences to people like that of not settling today and being quite honest about that. So you say, well, if we do walk away from the mediation today, and you do go to court because you want to punish that person, what is that going to look like? How long is that going to take you? Is that going to be stressful for you? Do you think that you win? If you do win, what will happen? Will you get what you want? And quite often that can help to really concentrate the mind of parties on what it is they really need. But it is very difficult when you have that initial layer of anger. And it does take time to get below that, I think.
Right, sir. So another aspect which is brought in by one of the students is that how can you protect the privacy of the parties during the process as there is no constitutional protection available in mediation? So we have arbitration and we have privacy laws. So how is it reflected in the concept of mediation, sir?
Yeah, well, certainly before in England, for example, as I said, there are no specific laws which govern privacy in mediation, in most mediations, at least in England and in fact in Scotland. So the two ways in which this is done is through contractual confidentiality, where the parties, before they mediate, they will sign an agreement with the mediator that the proceedings will be confidential, they'll be private, that neither party will disclose information outside of this room, and equally that parties will not lead anything which is said in the mediation in any subsequent litigation. They cannot cite the mediator as a witness, for example. But contractual confidentiality in England only goes so far, in the sense that the courts can override that, and they can say that nonetheless, in the public interest, they may sometimes want to see what happened in a mediation. And the other rules which apply here are these without prejudice rules, which under the common law developed over many hundreds of years have been present in England, which are there to encourage parties to be free and frank in their conversations when they're trying to negotiate prior to a case going to litigation. And those rules also apply to mediation. But as I said before, the rules are not certain. And I think that having legislation setting out confidentiality requirements and setting out the circumstances in which confidentiality could be waived, because of course sometimes it has to be. If you're complaining about the other party making misrepresentations, or the mediator acting in a very poor way, putting pressure on the parties to settle, misrepresenting things, then of course there may be a need to unravel that mediation. But we need to know when that can happen, and I think having legislation is really useful in clarifying that.
Indeed, sir. So our next question, which is coming from one of the viewers, is that how can you bring more finality or conclusiveness to the settlement agreement so the same issue does not later lead to a lawsuit?
Yeah, so this is quite an interesting question that arises, I think, quite a lot. It's a really good question. So obviously, in most mediations, they result in a contractual agreement, which is enforceable as a contract. But of course, parties may find that that's not necessarily acceptable to them, or they may be concerned about that, because if the contract is breached, they then have to go in and try and enforce that contract. So in some scenarios, a mediation outcome can be lodged with the court, where it receives the same status as a court judgment, so it's on its face enforceable, and that can be valuable. And we've seen that certainly in some contexts, in England, for example. But what I would say about this is that I think this problem is actually overstated, and that it's a fear about using mediation, which in reality doesn't happen that often. If you think about it, in a mediation, an outcome is only reached by the parties if they want to reach it. And they dictate the terms upon which it's reached. And they spend some time crafting that agreement, they sign up to it. So I think it's quite likely, and evidence suggests actually, that these agreements are much more likely to be adhered to by the parties in practice than something imposed, upon them. So in arbitration, for example, or litigation, if we get an award or a judgment that we don't like, we will try to avoid it. We will look for ways to avoid it. We will seek to appeal it. So there needs to be further enforcement grounds. But the issue doesn't arise as much in mediation, in my experience. I mean, obviously, the Singapore Convention that I referred to a little bit earlier on, that convention, of course, brings in a uniform enforcement mechanism to enforce mediated outcomes across borders. And that was seen to be very important, and the lack of such a mechanism, obviously in arbitration, you've got the New York Convention that provides that, but the lack of that in mediation was seen as being a real weakness of the regime. Now, I'm not actually convinced that it's needed, really, because the reality is that the cases settle anyway, and that parties will adhere to those agreements. But parties that don't have that much experience may fear mediation because of this issue. So I hope that's given you a few things to think about in response to that question.
Absolutely, sir. Sir, the next area which I would like to touch on is, after this pandemic, the world has been affected. All the economies around the world has been affected, which has given a rise to a lot of disputes. Many people have lost jobs, many people were not paid, many people have been laid off, and contractual obligations could not be followed. So many disputes have arisen. So how do you see the scope of mediation after the pandemic situation?
Yeah, thank you very much for that question. I think it's a really good question. There are two things here. One are disputes which are arising because of COVID, because parties couldn't, for example, fulfill contractual obligations, and parties, and lots of different problems in commercial matters. So you'll have disputes around frustration of contracts and force majeure and all these things, and lots of those cases. But equally, you've got lots of other cases which could not be resolved because of the pandemic, where courts were limited in what they could do, and there's evidence of that across many jurisdictions. In the UK, there is this backlog, certainly. A colleague of mine, a friend of mine, Tony Gees, is launching a Bust the Backlog movement. And we're thinking about ways of helping with mediation as a way in which to help bust that backlog. So I think definitely yes, it's quite possible that many of those disputes could be resolved by mediation. And I think what's problematic in the UK, at least at the moment, is that there's still a limited availability in many areas, lower level disputes, perhaps tribunals, for parties to be directed properly to mediation. So we need to fix that and find ways of signposting mediation in a better way, selling it more appropriately to parties, because mediation could absolutely be used. And I think particularly in the moment, we're talking about now online mediation. There's been a huge increase of very efficient online mediation in recent times, which means that geography is less important. Parties don't have to travel. They can participate from the comfort of their own home. So it makes it much more accessible. So yes, I do think there's potentially a great use here for mediation in resolving many of these disputes. And if you think about many of those disputes arising from COVID itself, where frustration of contract, force majeure are involved, they may present very novel ideas, novel arguments, situations that we couldn't possibly have thought about. This pandemic came from nowhere effectively and completely transformed our lives in a way that we couldn't intend. That is not a good environment for certain legal outcomes, you would think. So in those cases, I think certainly, yes, absolutely, mediation might be a very good way of raveling through the issues and helping parties reach appropriate outcomes.
Right, sir. So in that case, I would like to add on one more example. That is, during the pandemic, the Ministry of Home Affairs in India had passed an order stating that the salaries have to be paid to the employees during the pandemic time also, during the month of March to June. And thereafter, they cannot be relieved from their jobs arbitrarily. So later on, the Supreme Court of India interfered in this matter and stayed the operation of the order and said no coercive action shall be taken against the companies. Now, what if we had institutional arbitrations, and if the same dispute was referred to in institutional arbitration, the result would have been something else? What do you say about institutional arbitration here?
Yeah, I mean, I think that's interesting to hear that about the current state in India with that in terms of employees being paid off. And obviously, it's a huge issue here in the UK where many staff were furloughed and many lost their jobs and will continue to lose their jobs and creates lots of difficulties. Institutional arbitration, I think, yes, I think it could be a very good idea. Obviously, it's different from mediation. It does entail an imposition of a decision. But I do think that short form arbitration can be of use. It can be done online, a documents only idea, very efficient process where parties can be given swift, quick decisions. And in many areas of consumer law, for example, in the UK, there are many trade arbitration schemes that operate in that way, where for a very small amount of money and in a quick time frame, parties can resolve their disputes in a generally binding way quickly through short form arbitration. So yes, I do see there's a role for short form arbitration also. Although I do like mediation, I do see the need sometimes for adjudicative processes. So yes, I think that would be something it's worth considering.
Yes, sir. So I'd like to ask the last question. That is, okay. Where do you see mediation 10 years down the line, sir?
Oof. Yeah, well, that's a really, really difficult question to answer. I gave a paper at a conference back in 1996, believe it or not, so a long, long time ago when I was quite a young boy or a young man, and I started my work in the field at that time, and I'd become really blown away by mediation, thought it was a wonderful idea, and I was sure that mediation was going to develop exponentially and would increase very rapidly. And quoting Victor Hugo, I said something to the lines of, an invasion of armies may be resisted, but not an idea whose time has come. And I thought I was being very clever and suggested to everyone there that mediation would become very common and develop hugely in the next 2 or 3 years. And of course, it hasn't happened. And in the UK and Scotland and England, particularly Scotland actually, mediation development was incredibly slow. Lots of false dawns, people talking about mediation and people offering services, but not a lot of demand. And I think in many jurisdictions, obviously, we've moved on quite significantly, and we're seeing much more use. I am similarly positive now, but I do think that I've got better reason to be positive now than I was back 24 years ago. And I think that we're going to see mediation advance. There are advancements in many modern jurisdictions now, through the court system, through new legislation. I think lawyers are increasingly becoming on board with the process. Also, we're getting the message out to businesses, to the actual users. And we're managing to sell the process, I think, in a way that is relevant for them, that they can see the true value of it. And they're beginning to demand it from their own lawyers, and that's useful. And equally, I think the move online is going to be game-changing as well. That it's become, so instead of doing an international commercial arbitration in a neutral venue, all the parties traveling there, spending time there and spending huge amounts of money in accommodation, taking large teams over, it can be done online, and I think that will be the standard, or will happen very, very commonly. So the cost, the convenience will reduce. So yes, I am positive, and I hope I just have a little bit more up here now in terms of being confident about my prediction.
I thank you so much, sir, for joining us with Lex Erudites today, for giving us a beautiful session, wherein it's a very informative session, and we have learned a lot about mediation. So one thing which I could tell about mediation from the interactive session we had today is that an ounce of mediation is equal to a pound of arbitration and a ton of litigation, as rightly said by a great mediator. So I'm really sure of the fact that many of the law students will find it very inspiring, and they'll take a part towards the scope of mediation as well as the path of mediation. So this was a very informative session.
Oh, thank you so much. I've not heard that quote before, but I'm going to borrow it and use it. And the final thing I would say, that if people have any further questions, please feel free to contact me. You'll find my details on the website for my university. I'd be happy to engage with you further about that. So thank you very much for having me here. I really enjoyed it. It's great to catch up with you guys, and take care, and I hope everyone stays safe.
Yes, and now I would like to invite Shivdat Madhumedan, one of the co-founders of Lex Erudites, to deliver a vote of thanks. Mr. Shivdat, welcome.
Yes, thank you, sir. Good evening, everyone. Myself, Shivdat. And first of all, I would like to extend a sincere gratitude to Professor Bryan Clark for accepting our invitation and being a key speaker for a flagship webinar on mediation and civil justice system. And so it's worth mentioning that Professor was very favorable from the day one when I approached him with an idea of organizing a webinar on mediation. And thank you once again, sir, for providing us an insight into this particular topic. And I hope that this webinar proves to be beneficial to all our participants who are present here. Thank you so much, sir, and we look forward to your support to the Lex Erudites community in the future.
Okay, thank you so much, everyone. Goodbye. Thank you.
And I would also like to thank the moderator for our session, who's our patron, Advocate Gajendra Singh Rajpurohit, for hosting and effectively moderating the session. Thank you so much, sir. And yes, I would also like to thank all our participants and the entire team of Lex Erudites for helping us organize this session. And as mentioned by our moderator, Lex Erudites is inviting articles and blogs on different social legal topics, and you can get in touch with us. You can either mail us, and we've also developed an AI-powered platform in our website where our team will be providing all those assistance to the people who are coming up with a query on preparing an article and publishing it in our website, and we'll definitely help you out. Once again, wishing you all a great weekend. Thank you.